Order.
Border Security, Asylum and Immigration Bill.
We are now sitting in public and the proceedings are being broadcast. Before we begin, I'd like to remind members to please switch electronic devices to silent. Tea and coffee are not allowed during sittings. Today we will first consider the programme motion on the amendment paper. We will then consider a motion to enable the reporting of written evidence for publication and a motion to allow us to deliberate in private about our questions before the oral evidence session. In view of the time available, I hope we can take these matters formally without debate. I first call the Minister to move the programme motion standing in her name, which was discussed yesterday by the Programming Subcommittee for this bill. Minister.
Thank you, Chair. I beg to move the resolution.
The question is the programme motion as on the amendment paper. As many of those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. I call the Minister to move the motion about written evidence. Minister.
Chair, I move the motion in my name.
Thank you, Minister. The question is the motion as on the amendment paper. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Copies of written evidence which the committee receives will be made available in the committee room. I now call the Minister to move the motion about deliberating in private. Minister.
Thank you very much, Chair. I beg to move the resolution in my name.
As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now go into private session to discuss lines of questioning. Order, order. We are now sitting in public again and the proceedings are being broadcast. Before we start hearing from witnesses, do any members wish to make a declaration of interest in connection with this bill?
Thank you very much, Madam Chair. I want to let you know that I know Daniel O'Malley from Scotland through the Liberal Democrats. Thank you.
Noted.
Thanks. Daniel O'Malley as well.
Very popular. Thank you.
Added to.
If any interests are particularly relevant to a member's questioning or speech, they should declare them again at the appropriate time. We now hear oral evidence from the Refugee Council, the Scottish Refugee Council and the British Red Cross. We must stick to the timings in the programme motion the committee has agreed. For this session, we have until 12:10. Could the witnesses please briefly introduce themselves for the record?
Thank you very much, Chair. My name's Enver Solomon and I'm the Chief Executive of the Refugee Council charity.
Good morning, I'm Mubeen Bhutta. I'm the Director of Policy, Research and Advocacy at the British Red Cross. I think you've all been told that I'm a hearing aid user. I'm just having an issue with one of my hearing aids, so I might just need to step out and step back in if that's okay.
That's
As quick
okay.
as I can. Apologies.
And I'm Daniel O'Malley, Policy Public Affairs Specialist with the Scottish Refugee Council.
Thank you very much. I call Katie. I'll call Matt.
First of all, what's your view on the functions and objectives of the Border Security Command as set out in the bill?
So did you say the Border Security Command?
Border Security Command, yeah.
Yeah. So I'm happy to take that one. Yeah. So, look, our view is that this legislation is seeking to rightly disrupt the criminal gangs. The smuggling gangs, the trade is heinous, it is very damaging to people, and it needs to be stopped. And in that context, the Border Security Command is an understandable response to it. I think the issue that we have is that it's very difficult to simply rely on enforcement to tackle what is a complex and challenging situation. And by putting multiple eggs in the basket of enforcement, not just through the Border Security Command, but also by introducing a number of new offences, where our view, based on our frontline practice and work over many, many decades with people that come to this country from war zones, having fled persecution, having been victims of modern slavery, is that that strategy will fundamentally fall short, because it's very difficult to change behaviour by adopting primarily an enforcement approach, and an approach which is primarily driven by further prosecution and creating new laws. Essentially, new laws, like the offences created in the bill, are pretty much a blunt instrument to deal with behaviour that drives people to seek protection in other countries and to come here seeking asylum. And I think the evidence from the offences that have been created in previous legislation demonstrate that they haven't acted as a deterrent. So to sum up, enforcement is an understandable and legitimate approach, but it's only one approach, and it needs to be combined with other approaches that focus as well on international diplomacy and cooperation, and critically on additional legal routes. And if you look at the evidence, particularly from the US under the previous administration, that combination of three can have a demonstrable impact on reducing irregular arrivals. So I think the intention that this bill has set out, our concern is that it won't deliver the outcome, the understandable and credible outcome the government is trying to achieve, which is to stop the people smugglers, to stop people making dangerous crossings, because it is focusing too much on an enforcement-driven agenda.
And in terms of that, provisions you would have liked to have seen in the bill that aren't in the bill, you need to talk about a broader approach to what would you like to see in there that isn't in there?
Well, we would have liked to have seen more provisions that look at opening up targeted, additional humanitarian pathways, additional legal routes, additional mechanisms for people to seek humanitarian protection and to make applications for asylum without necessarily having to take dangerous journeys. We've advocated for a targeted humanitarian visa to be targeted and piloted in relation to specific nationalities where there is what's called a high grant rate. We would also have preferred to have seen the full repeal of the Illegal Migration Act. Not all provisions have been appealed. It's very positive that a significant number have been appealed, and it's very positive that the government has started to clear the backlog and has essentially ended what was the meltdown of the asylum system under the previous administration and under the failed implementation of the Illegal Migration Act. That is positive, but we think that that by retaining other provisions in the Illegal Migration Act, particularly the provisions around inadmissibility, by not repealing the differential treatment provisions in the Nationality and Borders Act, those are all elements that just contribute to greater dysfunction in the system. And the government's laudable and correct intention to bring greater efficiency, competence, functioning to the system is absolutely right. But by having multiple pieces of legislation that just will create greater dysfunction will not ensure that you get an effective end-to-end system. You do that by ensuring that you have reliable, speedy decision-making on asylum claims, that decisions are right first time, and that if people are granted protection, they're able to move through the system effectively with appropriate support, and if people aren't granted protection, you ensure the right steps are in place to support them to return. There needs to be much more of a focus getting the system to function with a clear vision for the purpose of the asylum system than I think about layering more and more legislation onto a system which is incredibly complex in terms of legislation and actually just creates further dysfunction.
Thank you. Before I go to the Minister, can I just check with Mubeen that you can hear us okay?
Are we talking to hear?
I was just checking that you can hear us okay. Do we need to speak louder?
Sorry.
She's asking if she can hear you okay.
Yeah.
Sorry?
She's asking if she can hear you.
No.
No,
It's
sorry.
not working. No.
Okay. If we speak louder, is that better?
Yes, that's helpful. I do apologise, it's a technical thing.
That's okay, just so that we know the level. Minister.
I'm going to try to speak a bit louder so that everybody can hear. I must say I'm having trouble hearing some because of the acoustics in this room, and we are quite full. So perhaps if our witnesses could speak a bit louder as well, I think that might help everybody. Enver, thank you for your evidence. In your evidence, you welcome the repeal of the Safety of Rwanda Act and the majority of the Illegal Migration Act, which this bill accomplishes. Could you say what your experience of trying to live with those acts being on the statute book was? Because there are those that argue that those series of bits of legislation were the only deterrent that we could have. Could I have your thoughts on whether they worked?
Absolutely. I mean, in short, they were a disaster. They were a disaster in terms of the lived experience of people that had come from places like Sudan, and we know the civil war in Sudan. They created huge uncertainty, huge anxiety. We saw a rise through our work in levels of great mental distress, even in levels of suicide ideation, as a consequence of those pieces of legislation which led to what we described as a system meltdown. It was a fundamental system meltdown that resulted in the system pretty much coming to a standstill, slowing down, with productivity in terms of asylum decision-making at its lowest levels since the height of the COVID pandemic. And it's absolutely right that steps were taken to address that and to ensure that the asylum system is functioning effectively. The asylum system has to deliver integrity. It has to ensure that the public has trust in a system that functions. And it functions by ensuring that decisions are fair, the great British value of fair play, by ensuring that decisions are taken in a timely fashion, by ensuring that taxpayers' money is well spent. That means you don't have billions being wasted every year on housing people in hotels that become flashpoints for community tensions. And it works effectively when you ensure that people are supported to integrate, to go on and contribute to communities across the country in the way that generations of refugees have done. And you critically ensure that if people are not granted protection, there are appropriate pathways to support them to return to the countries they've come from.
There are those, and I'd like other colleagues to comment if they wish, that say the only way of getting any coherence back to our system is to leave the European Convention on Human Rights and the and disaggregate ourselves from all of the human rights legislation. Do you think that that is an appropriate way forwards?
I'll let other colleagues comment.
I think in relation to the European Human Rights Conventions, frankly, coming out of those won't help anyone. It won't make the system any more efficient. For example, when it comes to the human trafficking provisions in the Illegal Migration Act, frankly, we want to see more of those repealed because, one, they undermine human trafficking protections in Scotland, but the broader repeal that has happened in terms of the Illegal Migration Act and the statutory instrument that was laid down before to alter the Illegal Migration Act has aided in, for example, the guardianship programme in Scotland, which gives a guardian to unaccompanied minors in Scotland as that was put into kind of statutory footing in Scotland under the Human Trafficking Exploitation Act of 2015. So that helps in terms of that programme because asylum claims were just not being made previously under the IMA. So that meant that that programme had thousands of more people in it and the programme just wasn't able to, it was operating but it was getting overloaded with more and more people. I think the wider point is that there are protections there that we are signed up to. For example, the UN Convention for Refugees. I think, frankly, continuing on with these is absolutely right, and repeal of them will not make the system any more efficient, and it will not be a deterrent to anyone.
Maureen, do you have a comment?
On the importance of the European Convention on Human Rights in relation to asylum.
I think I don't have anything more to add to important points that Daniel's made.
Thank you very much.
Thank you, Minister. Susan Murray.
Yes,
sorry, Chairman. Thank you. Just wanted to broaden this out. Enver's highlighted the Refugee Council's view on the bill being too narrow. What does the Scottish Refugee Council and the British Red Cross, what's their view on that? What do you think of safe legal routes as well?
Didn't quite catch the first bit of your question, but I think you're asking about safe and legal routes, is that correct? Yeah. I think I would endorse some of the comments that my colleague Enver has already made. I think we welcome the bill, we welcome the kind of intention of the bill around kind of ensuring there's reducing loss of life in the Channel, but it is only half of the story, so it's really important that we have that we look at the reasons why people are putting their lives in the hands of people smugglers in the first place, and that is because often there is no other choice, there is no route that they can take. So we would like to see more safe and legal routes, whether that's new routes such as enabling people to apply for a humanitarian visa in the country that they're in to come directly to the UK to then be able to claim asylum, or expanding existing routes such as family reunion so that there is more eligibility for people to use those routes. So it's really important to look at both sides of the coin together. So really, in a way, you could consider this bill to be looking at the supply of kind of this sort of activity, but it doesn't do anything about the demand, so that people will still need to make those journeys if no other routes are available.
I think for us, this is another migration bill on top of many migration bills. The system that people seeking asylum currently face is convoluted, it's arbitrary. The system is founded on hostility. As Mubeen rightly said, it's looking at, people crossing. It's about enforcement rather than about creating a more efficient asylum system. For us at the Scottish Refugee Council, that's what we are concerned about in the bill. You're kind of talking about the bill being quite narrow. There's aspects of it that are far too broad, that can be applied in too broad a manner. For ourselves at the Scottish Refugee Council, the aspects in terms of the bill, in terms of asylum, don't address a updating of the asylum system. You know, there's points of integration that should be considered as well. Nothing in the bill talks about integration of people seeking asylum while they're in the system. We commend the government for the speeding up of clearing the backlog, which is great, but there needs to be work done to help people who are in the system to integrate into the country. 75% of people who are in the system will typically be granted refugee status, so there needs to be work done to help them integrate into communities rather than having them in asylum accommodation or hostile environments. Now, the government is rightly looking at asylum accommodation. The Home Affairs Select Committee is also doing an inquiry into this, so we know the work is being done. So I think for us, the bill, we would have liked to have seen in it a point about integration. The work in Scotland on this is the new Scottish Refugee Integration Strategy, where we have an approach to integration from day one of arrival. We would like to see that extended at the UK level as well, mirroring what is being done in Wales also.
Thank you very much. Thank you. Mike Tapp.
Thank you, Chair. Thank you, Ms Solomon. Obviously, we've met previously in the past as well, and just to declare, I have worked for the National Crime Agency in the past and in a counter-terror role. I just want to go back to the points you were making around enforcement. I understand what you're saying. What are your views on, within the bill, the fact that there are also strong disruptive measures, which is, of course, pre-enforcement, such as search and seizure?
Well, I think those measures are legitimate, and as I said, it's important to take steps to disrupt the activity of gangs that are causing huge harm to the lives of individual men, women and children, who are often extremely vulnerable. And attempts such as the one you refer to, those powers, are important and have a role to play. I'm not disputing that. What I'm saying is that they need to be used proportionately and to be clearly targeted at the individuals behind the criminal gangs and the trade of the criminal gangs. And our concern is that with this bill, by broadening out criminal powers and specifically new offences, that individuals will be caught up in that process, and people who are coming across in the very flimsy, dangerous vessels will end up being criminalised through no fault of their own. And also that by using further legal powers, further laws, it's fundamentally, and this has been seen across a whole range of different areas of public policy, it's a blunt instrument to try and change the behaviour of people. People will not stop getting in flimsy dinghies, coming across the Channel or indeed coming across the Mediterranean because of new offences that they might face. They will probably know very little about the nature of those offences. They will know very little about the new rules that mean that if you get refugee protection, you will no longer be able to go on and gain British citizenship. They will, and we know that from our experience, they will know nothing about that. So it will not change behaviour. It will not provide the deterrence that I think it's hoped it will provide, which is why you need to use these powers in a very targeted, proportionate way and use them in a way that deals with the prosecution of the criminal behaviour but doesn't result in effect punching down on those vulnerable people who are getting into the boats because they want to seek safety. It will not change their behaviour. That is our experience from having worked with refugees and people seeking asylum over many decades.
Thank you, Ms Butler, and welcome this morning, and thank you for coming along and giving your evidence and your written evidence. I think you're absolutely right to focus on the new criminal clauses which are included in this bill, and just to comment on just how invidious they may be and how they might be broadly applied to asylum seekers. Would you agree that if we could find some provision or series of amendments that would remove asylum seekers from the focus of these new criminal laws, that might be a useful development. And one of the particular clauses which I'd like you to comment on is the one which introduces an offence of endangering another person during sea crossing. And I'm just wondering, if you're an asylum seeker or refugee with your experience in working with these groups of people, do they take any cognizance at all of the developing, hardening immigration and asylum laws in the UK when they are trying to get their family to safety from a war-torn region?
I think I would say not, and I would encourage the committee to, and I'll come to clause 18 in a second, to look at clauses 13 and 14. In our submission, we propose that they should be amended to ensure that the focus of the new offence is on people smugglers and not those seeking protection in the UK. Clause 15, we also said should be amended to include other items that are important for reducing the risk people face when attempting to cross the channel, and that the government should consult widely to ensure that the list is extensive as is necessary. But specifically in relation to clause 18 and endangering others, look, given that many of the boats now used, and committee members will know this, are barely seaworthy, they're overcrowded, the numbers that are crammed into them are increasing, that clause could cover many people, many more people than those whom the offence is apparently targeted at, i.e. the people smugglers. And I think during the second reading, the Home Secretary gave some examples, useful examples of the types of behaviour that could result in people being prosecuted, including physical aggression, intimidation, etc., the rejection of rescue attempts. We think that the wording should be amended to reflect specific actions to ensure that the offence is very clearly focused. But as I say, we would argue overall that these new offences are a blunt, extremely blunt instrument to change behaviours and will not have the desired effects of changing behaviours and stopping people getting into very dangerous, flimsy vessels.
I think I would add to what Enver's saying as well. I think, yes, it's a blunt instrument. When we have people come to our services, we operate a refugee support service across the whole of Scotland. When people come to our services, they don't talk about the deterrence or anything like that. They talk about what they see once they get here, and the environment that it causes around people seeking asylum and refugees is not that it deters them from coming here, is that once they're here, they feel that there's a threat to their protection, that their status here is at harm, is at threat. The language in these deterrents doesn't deter anybody from coming here, it just causes a hostile environment. Now that was the situation that was created with the previous bills and the previous government. We hope that this will not be what is continued on in the new bill and with other changes the Home Office is making. But at the end of the day, when people come to our services and they talk about stuff like this, it's about how it makes them feel when they're in the country, not about deterring them from coming here.
Thank you. Chris Murray.
Thank you, Chair. And I should probably declare that I used to work on refugee and asylum issues in Scotland, including with the Refugee Council in Scotland. You talked a bit about the fundamental system meltdown, Enver, when you were speaking, and the dysfunction that the IMA and the Rwanda Act had caused. And I wanted to ask you a bit more about that. Would I be right in saying that it had basically meant there had been a complete stop or a complete slowdown in any processing of asylum applications? And I want to ask, what's the impact of that, in your view, on the communities where asylum seekers are placed? And what impact does that have on, for example, the people that serve those communities as well, the councils, the charities? Does it make it hard to do their job? Does it cause local tensions? And then I would ask, if we're repealing those components of the IMA and the Rwanda Act, do you think that would address some of the challenges those communities are facing as a result of migration?
So, in short, what happened with the system meltdown that I was referring to was it did pretty much come to a standstill, and you had a huge backlog, ever-growing backlog, and people stuck in limbo indefinitely in the system. The number of people in hotels, in asylum contingency accommodation as it's called, reached record numbers. Hotels are being stood up in communities without proper prior assessments with relevant agencies around potential needs, that's health, NHS, around tensions vis-à-vis the police. We work in Rotherham, the hotel that was attacked, brutally attacked, where refugees were almost burned alive in the summer. My staff were in contact with people in the hotel who were live streaming what was happening. They thought that they were going to get burnt alive. That hotel in Rotherham should never have been opened. It was always going to be a flashpoint. It was located in an incredibly isolated area. There weren't appropriate support services. The local services were not properly engaged with in advance. There was no appropriate planning and preparation. And that story, I'm afraid, was repeated across the country because of the dysfunction and the system meltdown that the previous pieces of legislation resulted in. And it's absolutely critical that we learn the lessons from that and we don't repeat those mistakes. There is no need to be using asylum hotels. As I understand it, there are 70,000 individual places within the asylum dispersal system, roughly, today. If we had timely decisions being made in a matter of months, people moving through the system, dealing with a growing backlog in the appeals system as well by ensuring there's first-time right decisions with people having good access to appropriate legal information and legal advice and representation, which is a huge problem, you would begin to gradually fix the system. It will take time to fix the system and create efficiencies. But it's absolutely vital that there are plans to move away from the use of hotels that are taken forward rapidly, that the current contracts in place by the 3 private providers to provide dispersal accommodation are radically reformed because they just create community tensions because it's pivoted towards placing people in parts of the country where accommodation is hugely cheap and where there are going to be growing tensions without often support in place for people in those communities.
Thank you. I think Mubeen, did you indicate that you wanted to come in?
I didn't didn't quite fully catch your question, Chris. I do apologise.
It was about the impact on local communities of the dysfunction created by the Illegal Migration Act and the Rwanda Act, and how much you attribute that dysfunction, especially the growth of hotels for asylum seekers, to the Illegal Migration Act and Rwanda Act, which we're proposing to repeal.
I think I probably don't have a huge amount more to add to what Enver has just said, but absolutely there's a kind of, I think it goes back to what was said earlier about the speed of decision making, the time that people are left in accommodation, the suitability of that accommodation, the impact on their well-being, certainly in terms of what we see through our services, and that kind of need for a comprehensive strategy. I think it comes back to what we said at the beginning actually about what's in this bill and then kind of what needs to go alongside it that isn't in the bill around integration.
Thank you. Joe White.
Very much, Ms Butler. So how might the new offences impact individuals and organisations such as charities or NGOs that provide support to migrants? And I'll give an example. If a Vietnamese woman who works in a nail bar comes to one of your services, what mechanisms do you have in place to investigate and report any illegal working?
Do you want to go?
Would you like me to repeat that?
Dan, do you want to go? I'm happy to.
I can go as well. Could you repeat it again just for
Yes.
Mubeen?
Right, okay. How might the new offences impact individuals and organisations such as charities or NGOs that provide support to migrants? And I give an example. If a Vietnamese woman who works in a nail bar comes to one of your services, what mechanisms do you have in place to investigate and report any illegal working?
I think there's some. I think we don't fully know what the impact of that new offence will be because obviously it isn't enforced yet. It's helpful to see that there is provision in the drafting around kind of charities and their role, but it's not kind of certain how that will play out. And I think our concern is also that new offences could impact the kind of overall aims around the focus on seeking protection, so it could kind of influence behaviour or the ways that people offer support if there is concern that they might be caught.
I think really the point around the new offences and the deterrent aspect of this in terms of human traffickers and smuggling gangs, there's aspects in the Illegal Migration Act that haven't been repealed that are applied to human trafficking. For example, Section 29 of the IMA, which still keeps in a provision around disqualification from human trafficking protection. We would like to see that removed as well, because as you say, that individual coming to a service who's been in a nail bar and might have been human trafficked, which tends to be the case, might not come to any services because of fear of being disqualified from human trafficking protection because they may have engaged in criminal activity. If you've been human trafficked, by virtue of being human trafficked, you're likely to have engaged in criminal activity. This is the problem with aspects that have been left in the Illegal Migration Act and the Nationality and Borders Act. The Nationalities and Borders Act still has in it Section 60, which raised the threshold for referral to the National Referral Mechanism. Legal organisations in Scotland said pre-Nationalities and Borders Act, he had been a lawyer for a couple of years by then, had done one judicial review on the National Referral Mechanism. Since the Nationalities and Borders Act and Legal Migration Act, he's done about over 50 judicial reviews. This aspect keeps in it a freezing factor for people that are who've been human trafficked, that gangs and human traffickers can scare them by saying, well, you might not get this protection because there are these offences that could be applied or your protection could be taken away. So I think that's the aspect we would like to see removed to make sure that any offences aren't disproportionately affecting victims of human trafficking.
Thank you. Tom Hayes, this will be the last question. So please, if there's anything that you'd like the witnesses likes to say that you haven't already said, please do in this part. Tom?
Thank you, Chair. Part of the aim of this bill is to minimise opportunities for crossings, and part of doing that involves targeting the criminal smuggler gangs that are enabling small boat crossings to take place. Would you agree then that by having enforcement activities against those smuggler gangs, the effect will be a deterrent effect? That there's value in having enforcement activity in its own right, but that by virtue of minimising the number of crossings by disrupting the business model, you are therefore having a deterrent effect. And could I also just pick up on the point that Enver was making here about the Asylum hotel that was at risk of burning down? Would you therefore agree that the government's policies has directly and gravely put the lives of vulnerable asylum seekers directly at risk?
Well, I think the system meltdown that came about because of the fantastical Rwanda policy and the full provisions of the Illegal Migration Act left people in a state of permanent limbo, in inappropriate accommodation, in very vulnerable situations in communities where there are high tensions. So as a consequence of that, people's well-being was potentially being compromised. There's no question about that. And we saw that through our work. We saw the rise in stress. We saw the rise, as I said, in suicidal ideation. So there was very clear evidence from our practice about the impact of what as we described, was a system meltdown. I think going back to your point around enforcement, look, enforcement has a role to play, but it has to be one strategy combined with other strategies, one side of a multi-sided coin, a multi-pronged approach. And very similar to the evidence from actually dismantling drugs trafficking, often when you dismantle one set of smugglers or gangmasters, others will reappear and take over that part of the trade. It's very difficult to enforce your way and prosecute your way out of this challenge. There has to be multiple strategies adopted.
In our last minute, I don't know if Mubeen and Daniel, whether you wanted to quickly come in the last minute. Sorry.
Thank you. And my hearing aid magically started working. Just in terms of... business model. Just going back to what we said at the beginning about this being part of the story, safe routes, the other kind of half of it. Just one last point that I wanted to make is around clause 34 of the bill, which is around taking biometrics, and that introduces flexibility to take biometrics outside visa centres. We would like to see that extended to people who require to submit their biometrics for family reunion visas, because we know that people are making dangerous journeys to visa centres, multiple journeys, often in conflicts, often having to use smugglers to get across the border if the visa centre in their country is closed. So there's a real opportunity here to make that kind of strengthen that existing safe route by extending that flexibility in clause 34.
Thank you very much. Order, order. That brings us to the end of the time allocated for the committee to ask questions. I thank our witnesses on behalf of the committee for their evidence. If there are no further questions, can I thank the witnesses? Thank you. I'll move on to the next panel straight away. Yeah. That's repeating what I just said. We will now hear oral evidence from the Immigration Law Practitioners Association and Migration Observatory. Again, we must stick to the timings in the programme motion that the committee has agreed. For this session, we have until 12:40. Could the witnesses please briefly introduce themselves for the record?
Good afternoon, I'm Zoe Bantleman. I'm the Legal Director of the Immigration Law Practitioners Association, ILPA. Thank you.
Good afternoon, I'm Peter Walsh. I'm a senior researcher at the Migration Observatory at the University of Oxford.
Thank you very much. I call Matt Vickers.
Do you think the new endangerment offence will make any difference to channel crossings?
Well, evidence from academic research shows that the impacts of deterrence policies are fairly small, and the main reason for that is that migrants often do not have an accurate or detailed knowledge of policies in destination countries. Their understanding of those policies is often lacking in detail, wrong, and it's often influenced by what their smugglers or handlers tell them, and they have a vested interest, of course, in downplaying risks. There's also some statistical evidence looking more broadly at what drives unauthorised migration and asylum applications around the world, and that's found that domestic policy is not statistically one of the more important factors. Instead, geopolitical developments, conflict, that could be civil or ethnic conflict, international conflict, ecological disaster, regime change, those are all statistically much stronger drivers of unauthorised migration and asylum applications in particular countries. And then just finally, rounding out the picture, when an asylum seeker decides which destination country to move to, that calculus is influenced not just by policy. In fact, policy is one of the things that they take least account of. Instead, it's things like the presence of family members, members of the community, friends, language, and in some cases, in the context of small boat arrivals, actually escaping the Dublin system, because individuals may have claimed asylum in other EU countries. Maybe those claims are outstanding or they've been refused, and they understand that if they move to the UK, they can't be returned to the EU because we're no longer a part of the EU and a part of the Dublin system that facilitated that.
Thank you very much. Minister.
Thank you. You've just really argued, Dr. Walsh, that deterrent deterrence doesn't really work, and yet one of the big arguments that we had at second reading as this bill was introduced was that somehow by repealing the Safety of Rwanda Act and most of the Illegal Migration Act, we had thrown away the only thing that would work. Would you care to comment on that?
Yeah, so under the IMA, because the government proposed not to process people's claims, it wouldn't have known if returning those individuals to countries of origin would be safe or not, and that's where Rwanda came in. And there were always questions about the deterrent effect of the Rwanda policy. And for my part, I think whatever deterrent effect it would have had would have depended fundamentally on how many people were actually sent to Rwanda. You know, you could imagine if it was a large share of people arriving by small boat, then that may make people think twice. But if it were a small share, say only thousands a year, when we have tens of thousands of small boat arrivals, and that would imply that the chance of being sent to Rwanda is fairly small. And you could imagine that people then making the trip would just view that risk as, well, just as one risk among many others, and many other much greater risks, for example, risking their lives. So there were always real questions about the deterrent effect of the Rwanda policy and how many people would in fact have been sent there. Now, the last government said that that scheme was uncapped, and the Rwandan government said, we can take as many people as you send, but there were logistical challenges there, not least among them, where would people be detained? Now, at that time, we had about 1,800 people in immigration detention in the UK with a capacity of 2,200. I think you would have to detain people if you're threatening to remove them to Rwanda. So that was a very big initial stumbling block, putting aside whatever the capacity of those Rwandan facilities would have been, and more broadly the capacity of the Rwandan asylum system to process large numbers of claims. Typically it had processed only a few hundred a year, not the 10 or 20,000 that we do. So there were real questions there. And then the big risk was that, well, what do we do with people who are neither deterred from arriving or able to be removed to Rwanda? So that would be a subpopulation in the UK without legal status who would be here indefinitely. So they would forever have no legal right to remain in the UK, but we would be required to provide them with asylum accommodation and support at great cost. So that was the risk when it came to Rwanda and the IMA.
You just said something really interesting in your first comment, which was that you felt some of the people arriving on small boats are doing so because we are out of the Dublin system. In other words, because of Brexit. Were you surprised, perhaps, that in the withdrawal agreement there was no provision to try to opt into Dublin 3.5 or whatever it might have been called?
I wasn't surprised, but because I think that was consistent with the attitude at the time on the part of the government. But I did note that they did decide not to pursue a similar kind of agreement, which hampered them in a certain sense because there was no longer a mechanism to return asylum seekers arriving by small boat to the EU. Now, it is true that in the last 5 years or so that we were a part of Dublin, we were actually a net receiver of asylum seekers under Dublin. We received more than we sent out. That's for various reasons, including administrative reasons. But yes, it was striking that another similar kind of agreement or remaining a part of the Dublin system wasn't pursued, because it would have appeared to have hampered the government in that aim, namely to remove people arriving without authorisation to the EU.
Thank you. And Zoe, what is your view on the idea which has gained traction in certain areas of this debate, that the Human Rights Act and the ECHR are effectively preventing us from having a reasonable system, and the only way to have an asylum system that works is to pull out of those bits of agreements, those international agreements?
As the witnesses in the previous session have already said, those aren't the only international legal agreements by which we are bound. The UK has voluntarily agreed to be bound by a great many international legal agreements in relation to the rights of children, in relation to the Convention Against Trafficking, in relation to the Conventions on the Rights of Stateless Persons. There are a whole host in addition to the Refugee Convention and also the European Convention on Human Rights. One of the hallmarks, I think, of the new government has been this newfound commitment towards our international legal obligations and also restoring the UK's position as a leader in the international rules-based order, which both of the previous acts, in fact all three, the Safety of Rwanda Act, the Legal Migration Act 2023, and also the Nationality and Borders Act before it, eroded. And so I think it's fundamental to retain our commitment towards our international legal obligations. But it's also the case that there was a case in the High Court of in Belfast brought by the Northern Ireland Human Rights Commission in relation to the Illegal Migration Act, which found that it was not only the Human Rights Convention which was breached by the Illegal Migration Act, but also the very Windsor framework. So again, at a time when His Majesty's government is trying to reset the relationship with Europe, it seems a very strange thing to do, to try to back out of our human rights obligations. And again, the Good Friday Agreement and also the TCA with the European Union are both based on our compliance with the European Convention on Human Rights.
Thank you.
Thank you. Will Foster.
Thank you. If I may turn away from sort of historic strategic issues back to some of the wording in the bill, particularly would welcome your thoughts on clauses 13, 14 and 16 about the new offences. How effective do you think they would be? So more for Zoe, what do you think of the drafting of them? And for Dr. Walsh, how common do you think they would be used when so much of the preparation is done abroad?
In relation to the drafting of the offences, they are drafted in quite broad terms, and the defences are also quite narrow. I think there's a real concern, particularly on behalf of the legal professions, as to what would constitute a defence. For example, the defences relate, and I'll find the exact wording here, but one of the defences is where a person was acting on behalf of an organisation which aims to assist asylum seekers and does not charge for its services. For example, would a legal aid firm, which is charging the legal aid fund for services, come within the scope of this defence or not? I think that's a real question, but also imagine the much more practical question of someone who is, for example, in Calais with their family member, and their family member wants to get onto a small boat, and they're saying, no, don't get onto the small boat. Look here, this is what the weather is going to be today. And they show them the weather on their phone as to what it's going to be. That is something that could be useful to that person and helping them prepare for their journey to the UK. And it would be the collection and recording, viewing of that information. And it's not clear that such a person would have a defence if they were to, for example, reach the UK by a safe route, if there was such a safe route available to them. Because of the extraterritorial scope of the offences, even though that was done in France rather than the UK, they could potentially be prosecuted once here, of course, subject to prosecutorial discretion. And so there is a very large scope to these offences, and the defences are potentially not sufficient and holistic enough to account for all situations in which persons shouldn't be prosecuted and shouldn't be criminalised for that behaviour.
Thank you. Chris Murray?
Thank you. Dr. Walsh, you said something fascinating that the Minister picked up on about the Dublin system and the driver of people getting on small boats. Could you say a little bit more about that? Basically, first of all, what's the evidence for that? And then secondly, we know that the people getting onto a small boat on the French side of the Channel are part of a long stream of networks and illegal organisations and people fleeing, and they're travelling through multiple countries. So could you give us a bit more sort of detail on how those networks are functioning now and how they've evolved over the last couple of years in response to various conflicts and various drivers and the routes that people are taking?
Yeah, so just on Dublin, this provided a mechanism for asylum seekers to be transferred between EU member states and prioritised the idea that people should have their claim processed in the first state in which they arrive. There are other things that decision could be based on. One of them might be having family members in the country. That could also be the basis for a transfer. And there is emerging evidence when researchers have spoken with migrants in and around Calais, and they ask them, well, why are you taking this dangerous journey to the UK? And they talk about family, they talk about the English language, they talk about perceptions of the UK as being safer, and often they've experienced harsh treatment at the hands of the French police. And increasingly, they have specifically mentioned Dublin. And what we can infer from that is that they have an outstanding claim or a rejected claim, or claims, potentially in multiple EU member states, even though there are rules and processes to prevent that. They've exhausted what they view as the opportunity to receive a successful asylum claim in the EU. That leaves the UK, and they understand that because the UK is no longer a part of Dublin, that we effectively are not able to return them to the continent. So that's something that is actually fairly recent evidence that we've found. So on the smuggling networks and how they work, I mean, one of the big challenges is that they do operate transnationally, and so they're beyond the jurisdiction of any single authority, and that by its very nature makes enforcement more difficult because it requires quite close international cooperation. So the UK would be cooperating with agencies to operate under different legal frameworks, different professional standards and norms, maybe even speak a different language. And that challenge applies with particular force to the senior figures who are often operating not only beyond the UK's jurisdiction and the EU's jurisdiction, but in countries where there's very limited international law enforcement cooperation with both the UK and the EU. So I'm thinking of countries like Afghanistan, Syria, Iran, countries like that. I mean, more generally, the smuggling gangs, just to flesh out, they've become more professionalised, they're very well resourced, they're highly adaptable. There's a sense in which, law enforcement is constantly having to play catch up. They're decentralised, it's quite small groups of say 8 to 12 individuals spread out across the continent who are responsible for logistics, storing equipment like motors, engines in Germany, for example, that are imported to Turkey from China and then transported in trucks to France. So these networks also, they stretch out across the continent. And that really is why it's just so hard, really, for law enforcement to fight them.
Thank you. Pete Wishart.
Thank you. I'd just like to sort of pick up on that point because I think it's very important. And I think I saw somewhere where you commented there's a lack of evidence of the long-term effects of prosecuting people smugglers because they'll just be displaced. And it strikes me that if the people smuggling gangs have got effectively a monopoly on the irregular migration business, given that there's no other means or safe routes to get to the UK, surely all they're going to do with all the legislation this government's bringing forward is adapt their models just to accommodate what the government's introducing, because they always seem to be like there's a few steps ahead of government. And unless we tackle the demand, surely there's not going to be anything that we're going to effectively do to tackle these illegal gangs, particularly when we're going to be cutting international aid budgets, which is only going to exacerbate the issue, the problem, driving more people into their hands. And to Ms. Bantleman, I think you've written to the government urging them to amend the good character guidance to ensure compliance with the UK's international obligations. I just wondered if you could expand upon that and elaborate what you're intending from the government. And I think you're absolutely right to remind this government of all its range of commitments and international obligations. But if you could maybe go in that bit first to you, Dr. Walsh.
Yeah, so it is true that there's a real lack of evidence on what the likely impacts of specific policies to disrupt smuggling networks will be. But I would say these policies, they could assist in disrupting smuggling activity. If you invest more resources in enforcement and agencies have greater power of seizure, search, arrest, investigation, then you would expect that more smugglers will be brought to justice. The bigger question for me is, well, will that reduce people travelling in small boats? And there is this separate question of whether this will eliminate the market for smuggling, because what we do know is that there are a lot of people who are willing to pay a lot of money for the services that smugglers provide. Now, if the effect of these policies are to disrupt smuggling operations, now that could conceivably raise the cost of smuggling, a cost that would be passed on to migrants, and it may be the case that some are priced out at the margins, but I suspect that demand for this is fairly inelastic, and even an increase in price, people will just be willing to pay it. There's another challenge as well, which is that the people most directly involved in smuggling operations on the ground, the people who are tasked with getting the migrants to shore and the boats into the water and getting the migrants into the boats, it does not require substantial skill to do that job and substantial training and investment. So those individuals, you can apprehend them, and that does require substantial resource, but they can quickly be replaced, and that's why it's been described as being like whack-a-mole. So I think that is one of the real challenges here.
Just to add on that point before I address the second question, I completely agree with what Peter has said in terms of the most fundamental challenge in breaking the business model of smugglers is that smuggling will simply exist for as long as there's demand for it. And there will be demand for it as long as there are people seeking safety, for as long as we fail to have those accessible, safe, complementary routes for people to arrive here, for as long as carriers are too fearful to allow people onto safe trains and ferries and planes to the UK, people will feel that they have no choice but to risk their lives on these dangerous journeys, and their savings and their families' savings. And the focus of this bill isn't on tackling the trafficking or the traffickers or protecting the victims of trafficking. It draws its net much wider, and it's really about tackling anyone who helps anyone to arrive here and also tackling those who do arrive here, which leads me on to the second point in relation to the good character guidance. And there was a recent change on the day of second reading of this bill in the House of Commons that also resulted in a change to the good character guidance, which is a statutory requirement which individuals must meet in order to become British citizens. And that guidance said that anyone who arrives here irregularly or enters here irregularly, it uses the word illegal actually, I substitute it with irregularly, shall normally not be have their application for British citizenship accepted, no matter how much time has passed since then. And fundamentally, under the Refugee Convention, Article 31 says that individuals should be immune from penalties. And it's a protective clause. It's aimed to ensure that exactly this kind of person, exactly the kind of person who doesn't have the time, isn't able to acquire the appropriate documentation, who does have a very short-term stopover in another country on the way to the UK, and who is allowed to choose their country of safety, can come here and is immune from penalties. There's also an obligation under the Refugee Convention to facilitate the naturalization of refugees. There's also many other conventions which we mentioned there, including in relation to the Convention on Elimination of Discrimination Against Women and also the rights of the children. Children have a right to obtain a citizenship. And so stateless children shouldn't be barred from obtaining British citizenship. In addition, they shouldn't be held accountable for things which were outside of their control. Children placed on small boats may have had no control or understanding of what they were doing when coming to the UK. So arriving here in a way that was outside of their control, in a way that the government considers to be illegal but is not illegal under international law, is not a reason for them to be barred from citizenship. It's the substance of what we've said.
Thank you very much. I think this may be the last question, unless anybody else has indicated. Margaret.
Thank you, Chair. I was going to ask Dr. Peter Walsh. Enver Solomon, in his previous evidence, said about the meltdown of the system and the immigration system, and it chaotic. I think we all heard that. I just wonder, though, that I'm on the Home Affairs Committee, and we're looking into this as well, and we've had quite a few people, different groups, come in and give evidence, and they were slightly more optimistic than what's been said today. I just wonder, the world is, we're all in mass communication. When this starts to get rolled out, I think word will get around, won't it, that, if there was a chaotic system that everything had ground to a halt before, if you as the gangmasters, you're going to run the boats, as time goes on and you get to grips with that would seep through, would you think? And then that wouldn't be the case, that people would necessarily want to risk the boats with the gangs.
The thing with communication is, for so many of these individuals who are travelling, the information that they receive often comes from their handlers, their agents, smugglers. Sometimes it does come from people who have already made the trip, they're already in the UK, but that has the effect of emboldening them. I'm not sure what the prospects would be for them learning about what the reality is of the UK's asylum system more broadly. But for sure what we see is that typically knowledge of that system, whether it's chaotic or whether it functions well, is always filtered through their agents, smugglers, handlers, and those they know in the community who are making the trip or have already successfully made it.
Thank you. I've got two quick questions I want to squeeze in. Tom Hayes.
Thank you, Chair. We hear that because the Rwanda deterrent, so-called deterrent, never actually happened, that it's hard to assess whether it was a deterrent or not. But in a Q&A that you published on the 25th of July, Dr. Walsh, you say that the deterrent impact of the policy would likely depend on the number of people who would have been sent to Rwanda, and you estimate that probability of people crossing the channel in a small boat being sent to Rwanda around 1 to 2%. You also say in the Q&A that there was no evidence that political discussion surrounding the Rwanda policy deters small boat arrivals. And in fact, we saw from the day that the policy was announced to the day it was scrapped, 84,000 people crossing the channel. Do you want to say anything about the efficacy of the so-called deterrent? And relatedly, would you agree that it's hard to make emphatic assessments of the fiscal burden of immigration owing to the quality of data that's available?
Yes, I would agree with that last point. On the deterrent effect of the Rwanda policy, it never came, it was never implemented. So I think it would be unfair to say that it didn't have a deterrent effect. Policies of that kind will only have that effect, or typically the bulk of that effect, once they are implemented. Now, the 1 to 2% figure, I can't remember what the source was for that. That was the best. I mean, this is a somewhat old research paper now, but that at the time was the best estimate that we could point to. It wasn't an estimate actually made by myself or colleagues. Can you see what the source was?
I can. So to read out, it says, if only a few hundred asylum seekers were sent to Rwanda each year, as suggested by the Deputy Prime Minister and Home Office modelling, and unauthorised arrivals have continued at rates similar to those seen in 2022 and 2023, and this is published in 2024, then the probability of a person crossing the channel in a small boat being sent to Rwanda would have been small, around 1 to 2%.
Yeah, and so I recall the Home Office's modelling now, which was subject to a whole range of caveats. They were actually quite cautious about the estimates. That was kind of the best available figure that they had at the time. It was in part based on the capacity of Rwanda to process claims. Could have gone up. We just.
Can I quickly just get Kenneth's question in?
We've heard from Dr. Walsh about the small gangs and how they operate, very difficult to work against. But can I ask what engagement they've had to greater understand the government's position here, and whether they might outline their evidence that directs us in an alternative approach? And the second thing is, it's been very interesting this morning to listen to the migration and people who have come across and what doesn't deter them. It would be interesting to hear if there is anything that they have spoken to about which does deter them, and if they could outline that too.
There's less than a minute left. I just wondered if Zoe wanted to quickly come in as well. Less than a minute.
Things that can have a really strong deterrent effect. They operate not quite via psychological deterrents like this, but physical interception of boats in the water. So the case of Australia, I think, demonstrates this quite clearly. They had an offshore processing plan, but actually they had a huge decrease in numbers arriving by unauthorised boats. They actually went down once Australia was intercepting physically those boats in the water and returning those boats to countries of departure.
Yeah. And can you answer the original question I asked about the engagement they have had, which with the government, to understand how, you're saying that, small gangs are very flexible, but obviously the government are saying, they're going after those gangs.
Order. That brings us to the end of the time allocated for the committee to ask questions. I thank our witnesses on behalf of the committee for their evidence. Thank you very much.
That's relevant to children.
Well, you might have done two things, that's yours as well.
Thank you. We will now hear oral evidence from the Children's Commissioner for England and Wales. Once again, we must stick to the timings in this programme motion. For this session, we have until 1 p.m. Could the witness please introduce herself for the record?
So, good afternoon. I'm Rachel de Souza, the Children's Commissioner, the Independent Children's Commissioner for England. It's my job to protect and promote the rights of children. Since I took up this role, I've made working with children who are illegal immigrants who arrive at Kent one of my top priorities. I go down to the Kent intake unit. I've talked to all the children who are in hotels. My independent advocacy body has supported hundreds of these young people. I've used my power of entry powers to go in and look at the situation they're in. I've used my data powers to track safeguarding issues around them. So it's been something that I've had a real thoroughgoing work of for the past 4 years.
Thank you very much. I call that. Pass it to the Minister. Minister.
Thank you very much. What is your general opinion of the changes that would be introduced in the current structures on immigration law with the repeal of the Safety of Rwanda Act and vast majority of the Illegal Migration Act and the strengthening powers for the Border Security Command, which are a central part of this Border Security, Asylum and Immigration Bill?
Look, I don't want to see any child come across the channel in a small boat. I've sat on those small boats myself. I've talked to children who've come on them. I've seen 8-year-olds come across on them. I've seen blind children come across. I've seen children with Down syndrome come across on those small boats. They are dangerous. Children, one sticks in my mind, a young Iranian lad who saw his parents killed in front of himself, was killed in front of him, was taken by smugglers, didn't know where he was going, come across on those boats. So anything to stop these wicked traffickers, in my book, is good, as long as we're protecting children and protecting safeguarding as well. You will know that I was very vocal about the illegal migration bill, particularly the bits that were conflicting with the Children's Act, because when a child is on this soil up to the age of 18, they need the Children's Act to be what has to have authority over them. I was very worried by the Home Office accommodating children. I'm really pleased to see that has now been checked. I know I went to everybody was working so hard, the Home Office officials, to do their best by those children, but the Home Office accommodation, the hotel accommodation was not suitable. Children were languishing without proper safeguarding in inappropriate places. Children's social care must look after children who are unaccompanied, and so I'm pleased to see that change. I'm pleased to see Rwanda repealed, because basically most children, it wouldn't from the perspective of children, because children told me, and the children who came told me, wouldn't have stopped them coming. They were just going to disappear at 18. It would actually end up putting them at more risk. So, I had concerns about that. I also had concerns about children who've been settled here for a number of years, then at 18, been liable to be moved to Rwanda. So I'm pleased to see that changed. So in general, I am really supportive of this bill. There are some things that I'd like to see it go further on. I do have some concerns, but in general, very supportive. Thank you.
Thank you, Minister. Will, sorry.
Thank you. What are the things that you'd like to see the bill go further on? We just heard from a legal director at the Immigration Law Practices Association that they've got some concerns on the government's rhetoric, at least, if not some of the actions against international law, particularly about children. Could you comment on that as well?
Okay, so I suppose because I see so many of these children and work with them directly, I'm often thinking practically about what their lives are like and how to ensure they're okay. So I tend to be coming at your question from that approach. One of the things I'm worried about is that the potential for scientific age assessment and the potential for getting that wrong. There was a fantastic debate in the other house where the Dental Society, Lord Winston and others talked about the lack of clarity around and the sort of slight vagueness around age assessment procedures. Now, what I would say is the social work team down at the Kent Intake Unit are fantastic, and they've really developed a strong approach to knowledge about how to get those age assessment decisions right. Understanding of school systems and other things about young people. So I think we need to be really careful around the age assessment side. I also, I'm going to be worried about safe and legal routes. Look, let me give you two examples. I have two young ambassadors out of my a large group. One is from Ukraine, came on the Ukraine scheme, managed to complete her Ukrainian education and her UK education at the same time, is going to King's College, had nothing but support. One from South Sudan, came, no safe and legal route, came as an illegal immigrant, FGM, there's some really serious issues with her, found it hard to find somewhere to live, hard to get a job. She's now at Oxford University because we've supported her and she's brilliant. But just two completely contrasting issues. So for children, I think especially, I stood and welcomed off the boat a child, the first child who came from Afghanistan, who spent his nights weeping because, he didn't know whether his parents were alive. So that safe and legal routes issue, particularly for children we know are coming from these war-torn areas, and we know they're coming. We really need to think about it and think about support for them. So and I think that maybe answers your tone question as well.
Thank you very much. Thank you, Chris Murray.
Thank you. We heard from the previous panels about how the Illegal Migration Act and the Rwanda Act had caused wholesale dysfunction in the immigration system, especially in asylum. And I wanted to ask you about the impact that dysfunction has had on children. So as we are moving unaccompanied asylum-seeking children from Kent around the rest of the UK, how dysfunctional was that system? And what was it like for local authorities that were trying to support them and local communities who have statutory obligations for child protection?
Yeah, so look, the down at Kent, obviously, as needs as must, the hotels were set up. So I visited the hotels that children were in. wholly inappropriate, many children languishing there for months without English teaching. Kent doing its best, Kent Council. Some of the best provision I saw for children just arriving were put on by Kent, who had managed to get school going, who had managed to get interpreters in, but they were overwhelmed. Now, what I would say, to pay tribute to the local authorities around the country, that whenever there was a very young child or a disabled child, they'd step up and come down and help. But it was hard to get the National Transfer Scheme going, and the children were confused by it as well. The Highlands offered a range of places to some of the children, and they were like, where is the Highlands, and what are we going to do there? So, you know, and I mean, it felt, you know, discombobulated at best. It was really, really, really tricky. And of course, let's not forget, a lot of these children are older teenagers, and a lot of the provision that they were going to was basically not to care. It was to a room in a house, you know, with all sorts of other older, you know, teenagers and older, you know, left to fend for themselves, which was incredibly disorientating. We do have a problem with 16 and 17-year-olds in the care system, and this just was, and there was massive stretch on the social care. Every DCS I spoke to, every director of children's social care I spoke to said, it's a massive stretch on our budgets. We don't know what to do with these children. We don't know how to do it. Now, I think we could be more innovative. And again, you know, there is massive goodwill out there in the country. We should be looking at specialist foster care and not sticking 17-year-olds in rooms in houses on their own. There are so many things we could be doing actually to try to make this better. And, you know, settling children in communities, proper language teaching. The number one thing children tell me they want, given that they're here, is to learn, to be educated. So that they can function well. And for me, you know, particularly some of the children that I've seen that don't in any way like mirror the stuff we read in the media about sort of freeloading, coming here for whatever. They're really serious cases, most of them. Want to try to, given that they are here, learn and be good, productive members of our communities. So there's much we can do.
Thank you. Pete, sure.
Thank you. And can I just commend you for the work that you do? I have observed it, and I think what you do is amazing, and I just want to pay credit and tribute to that. But you're absolutely right to raise some of the issues about some of the age assessment procedures and some of the almost quasi-scientific applications, and you're right again to reference the debate in the House of Lords. I think they captured that quite well. But why do you think there is this increasing trend to try and label children, quite obvious children or teenagers, as adults? And we're keeping parts of the NABA bill, which is going to be a feature of the bill as it goes forward. And there's concerns again about modern slavery and the impacts on children with all of that. So is there anything, like amendments that we could bring into this bill which would help deal with all of this, which would meet some of these concerns, and so we get into a much better place with how we deal with children and their asylum system? So
obviously both of those issues are concerns of mine, age assessment and the modern slavery provisions and them not being allowed to be applied. Look, on age assessment, it is important that we know how old children are. I've seen 14-year-olds in hostels with 25-year-olds, you know, totally inappropriate. I've seen girls who say, I'm not 18, been age assessed as 18 and been put in adult institutions with adult men. You know, it is, and we don't want people masquerading as children to be put in with younger children. So we do need to do everything we can to determine age. I do think the technology around age assessment, you know, scientific age assessment, is going to be difficult, not least because, you know, when you're dealing with an international population, as Lord Winston talked about, it really is difficult to be precise, and being precise matters. When children arrive at Kent, they get their new clothes, you know, if they're sick, they're put in a shipping container till they're not sick anymore, and then they have to maybe sleep a bit on a bench, then they're age assessed. And when that age assessment is the most important thing about the rest of their journey here. If that goes wrong, that's it. You know, they are. You're an adult, and it's. You know, if you get that wrong, so it's a really important, tricky thing, and you know, they're often not supported. I would say there are things we can do. I always look for solutions. You know, maybe we ought to be saying, this is obviously a child, this is obviously an adult. There is a group where there are questions, and perhaps we should be thinking about housing them and spending a bit more time to work out how old they are and try to get the evidence rather than making these cut decisions that are going to change people's lives. For you know, like I say, I found a 14-year-old boy in Luton there for years with 25-year-olds, really, really upset. On the modern slavery provisions, all I would say, and I hope this is helpful, I have seen with my own eyes, like a 16-year-old Eritrean girl arriving at Kent with an older man, her boyfriend, who she obviously said, you know, it's fine, I'm 16, we can come in, lost her parents, you know, that it was obviously going to be trafficking, and we need this, you know, the parts of this bill to be picking that up. So that's real. So, you know, we do need to be really careful about those things.
Thank you. Thank you. We've only got 2 minutes left and 3 questions. So, Jo White.
Thank you. Just very, very quickly. Can I say thank you for the work that you do? My biggest concern is those children who come into the UK that you don't even know they're coming in because it's hidden. So they are clearly victims of modern slavery or child sexual exploitation. And I think it's important, you said just now, how we need to stop the gangs that bring them across. How confident are you with the new border commander and his anti-terrorism powers that he will actually be able to track those gangs down and actually smash them?
So that's the first question I asked the National Crime Agency when I came into role. I said to them, could you find every child in this country? Can you do it? And he said, with enough resource, we could pretty much do it, apart from you know, some of the Vietnamese children who are trafficked into cannabis factories and things like that. So I think with resource and with the new border command, we're going to get a lot nearer, and we need to do it.
Thank you. Tom Hayes.
Thank you, and thank you for all of your work. In April 2023, you wrote to the then Home Secretary requesting information about children accommodated in hotels. You then said 7 months later, when you received the information, that it was 7 months past your deadline, and the information itself, the quality of it, was deeply troubling. Yeah. Can you make any comments around how difficult or easy it was for you to discharge your statutory duties as Children's Commissioner in working with the last government to safeguard children?
So the Home Office then was the only place the only department that failed to answer my data request in time and gave me imperfect data, but I didn't stop and kept going. I have to say, much better now. So I was able to speak. I did have access to ministers. I was always able to make my case, but I didn't get that information in a timely manner. I did get information in the end. What I'm worried about are what has happened to those children. So those children, you know, I've got the data. The data we were after was safeguarding data that showed, you know, all the concerns. And the reason I asked for it was I knew that the safeguarding in the hotels wasn't as it should be. And, you know, what we got was the data on children who'd been attempted victims of organ harvesting, rape, various other things, but also the number of children missing. Many of those children we still don't know where they are, and that's not good enough. I think the whole tone has changed, and I'm hoping for still, I think still, you know, wanting to stop those small boats, but much more pro-children, so let's hope so.
The last question from Becky Griffith.
We heard earlier about the Rwanda Act and the IMA and the impact that had on a massive escalation in the use of asylum hotels, and I wondered whether you believed it was actually our children and young people that were disadvantaged the most. You talked a lot about not wanting to see a single child come across in small boats, but we also need to focus, of course, on what is happening when the asylum hotels are unsuitable, not least that when they are unsuitable, those young people are so much more vulnerable to people outside of those asylum hotels, criminals that operate in the UK, who then seek to do them harm.
Yeah, absolutely. I mean, the numbers of tales and stories from children about how virtually the entire rest of the hotel had been picked up and driven off by gangs. You'd just walk outside and be picked up and you'd go. It was really not good. Some of those children made their way back because they were being exploited so badly, made their way back to Kent. It was really terrible. There were not proper... One of the reasons I don't want the Home Office to accommodate children. The Home Office are great at many things, but they shouldn't have anything to do with children. Children's social care should be looking after children. They never were able to put in appropriate safeguarding. They weren't managing to structure children's days, despite their best efforts. And they didn't have the personnel that could deal with this. So children were going missing regularly. Some are still missing. And they had kids there for months who weren't learning English. What are they doing? Whereas straight into Kent, when they were straight into Kent's care, they had them in school, learning English, learning about what it's like to be in England, being able to understand their rights, get used to the country they're in. But I do fear that many of those children came to terrible ends.
Order. I'm afraid that brings us to the end of the time allocated and allotted for committee to ask questions. I thank the witness for her evidence today. That brings us to the end of our morning session. The committee will meet again at 2 p.m. this afternoon here in the Boothroyd room to continue taking oral questions. I invite the government whip to propose the adjournment. The question is that further consideration of the bill be now adjourned. As many of that opinion say aye. On the contrary, no. I think the ayes have it. The ayes have it. Thank you. Order.